2019. And after these three panels, I think Representative Hicks will be briefly talking to us about an amendment to, I think, 2919. Good. Let me call the first panel on 3460. Jeff Sugarman, Mark Imhoff, and Tom Chambers. Mr. Chamberlain, we haven't had you before this committee for a while.
It's been a while. Yeah.
Go for it.
Chair Greenlick, members of the House Healthcare Committee, my name is Jeff Sugarman. I am here today representing Oregonians for Medical Rights. Oregonians for Medical Rights was formed in 1998 as a political action committee to pass the original Oregon Medical Marijuana Act. I was happy then to be a director of that act, and I'm happy today to bring in House Bill 3460. When the original Medical Marijuana Act was passed in 1998, it allowed patients to grow their own medicine or to designate someone to grow it for them. Over the years, as new patients have entered into the system, they've had much more difficulty finding a grower and being able to obtain someone to grow for it, or they are just unable themselves to grow the medicine for a variety of reasons. Thus, they or their caregivers have to turn to the black market to get the medicine that they need. In 2005, Senate Bill 1085 by Senators Cruz and Morissette increased plant limits and possession amounts, leading to an increase in the amount of marijuana legally being produced under the law. This bill authorizes a legal and a regulated means of getting excess marijuana into the hands of patients who today cannot grow their own medicine. In recent years, between 150 and 200 facilities have started operations across the state providing medical marijuana for legal patients. Portland, and in many communities, Portland, for example, law enforcement has taken a hands-off attitude. In other communities, however, these dispensaries have been raided and shut down, and oftentimes leaving registered legal patients without their safe access to the medicine that they need. House Bill 3460 provides a consistent and regulated approach to ensure marijuana produced under the Medical Marijuana Act ends up in the hands of patients who need it. And I'd like to spend just a minute going through several of the key components of the bill. First, through a process very similar to that for patients and growers, the Oregon Medical Marijuana Program is authorized to license and regulate what we call in the bill medical marijuana facilities. The bill contains many of the same provisions regarding past criminal conduct and provides OHA with broad rulemaking authority to ensure that the medical marijuana facilities are regulated properly. It also allows OHA to establish a fee that covers the entire cost of this particular program. House Bill 3460, while it does grant that broad rulemaking authority, also places some regulations in law that these safe access facilities must follow, including they cannot be located within 1,000 feet of a school. They must be located within commercial, industrial, or agricultural districts, but not in residential districts. It requires testing for pesticides, molds, and mildews to protect patients. It requires the facility to meet certain security requirements, and it does require, as I mentioned, background checks on owners. One of the most important provisions of the Act is that the patient is still the owner of all the medicine that's being produced. Under the original Oregon Medical Marijuana Act, the patient is the owner of all the medicine that is produced by themselves or their grower. This bill requires that the patient authorize their grower to transfer the marijuana from the registered grower to the medical marijuana facility, and from the medical marijuana facility to other registered patients. It also requires tracking of the marijuana coming in and going out to ensure that the marijuana being sold in the medical marijuana facilities comes from a legally registered grow site. Finally, the bill does require testing for pesticides, molds, and mildews. This critical provision, I think, deserves specific mention. Recently, one of the local news stations had a story about an Oregon gentleman who went up to Seattle and bought medical marijuana, brought it back, and it was laced with mold. He ended up getting very sick and ending up in the hospital. As a part of their research into that, the television station also interviewed someone who actually runs one of these testing centers in Wilsonville, and that person reported that as much as 1 in 20 samples that he tests will test positive for some kind of pesticide while they're out there. So in seeking a safe access for the patients, we believe this testing provision is one of the most important aspects of it. I think House Bill 3460 is a moderate bill that addresses two specific problems under OMA, providing safe access for patients and hoping to ensure that marijuana grown for patients under the law.
OMA.
I'm sorry, sir?
You mentioned OMA. This was.
Oh, I'm sorry, Oregon Medical Marijuana Act. I apologize. And the act ensures that marijuana grown for patients under the Medical Marijuana Act actually ends up in the hands of patients who currently have no safe access. Provides a regulated and workable process that can be monitored, modified, and improved as needed. The Oregonians for Medical Rights urges passage of House Bill 3460. Thank you.
Chair Greenlake, members of the committee, my name is Tom Chamberlain, and I'm here testifying today as father. I'm testifying in favor of House Bill 3460. On January 15th of 2012, my son was involved in what should have been a fatal car accident. An accident that left him a C5 quadriplegic with an amputation below the knee on his left leg. Needless to say, this accident changed my life, my family's life, and my son's life. My son Joe originally took a regimen of medication from several different medications for pain, anxiety attacks, pills to put him to sleep, pills that would cut down on the spasms, all the side effects that actually may have treated the symptom, but the side effects actually made his life more difficult than it should have been. Joe applied for to be enrolled in the Oregon Medical Marijuana Program. To say I was skeptic at first would be an understatement. But I have to tell you, today he's weaned himself off of almost all of his drugs. And while marijuana isn't it's not the answer to everything, it makes things tolerable for him. It makes things manageable for him. Joe isn't going to be able to grow marijuana by himself, and Lord knows he's not going to grow it in my garage. But each month I take him to the marijuana outlet, and they're everywhere in Portland, to get what I thought was, it was legal to go to an outlet. I didn't know until recently it was illegal. Nor did I know that the products he was purchasing weren't tested, so there was no assurance of quality. For those reasons, I stand here in support of House Bill 3460. Thank you.
Thank you. Just share this with
Hi, my name is Mark Impon. I was asked to come down here, so I'm new to this. I'm a senior software engineer, and I've worked in my home for over 30 years. I have a bachelor's degree and a master's degree. I moved to Oregon in 1988, and with my wife, we have raised a family of 3 children. I'm a pretty normal person, professional person. I have serious medical issues relating to knee and shoulder injuries, seizures, kidney stones, arthritis, and sleep apnea. I have sought standard medical treatment for all these conditions. I've had prescription drugs prescribed to me for all these ailments, including several major narcotics. All of these treatments have, to some degree, failed because of side effects and sickness. Recently, I had a total knee replacement. My surgeon, who has performed over 2,000 of these replacements, along with my family doctor of 30 years, are comfortable with me using medical marijuana to moderate and control this pain since becoming an OMT patient 3 years ago. I've been able to eliminate all prescription drugs. Have not had a single seizure. It controls my pain, allows me to sleep better. I wanted to make a point that I use this in the privacy of my own home, only in the confines of my house, and at night before I go to sleep. Because it works so well for my conditions, I do not need to take this during the day. The problems with the grower model to me is I'm 61 years old, I've never been arrested, never been charged with any type of crime. Finding a grower is difficult for me. Like everyone else, I treasure the privacy of my own home, and the use of medicine is a private domestic matter. Bringing a grower to my home to provide medicine means that I have to associate with somebody I do not know very well. I'm also totally dependent upon the grower's word and legal status. Growers provide entire prescriptions in large amounts. I am not comfortable having large amounts of medicine, a pound or more, sitting in my home. It's an open invitation to home invasion. As an example, no one would want a year's supply of a prescription narcotic such as oxycodone in their home. No doctor would ever do that. The dispensary model to me is a much safer and better alternative to the grower model for several reasons. Using a dispensary is no different than going to a Fred Meyer pharmacy or anything else and picking up a prescription drug. I'm allowed a selection of medicine and products and services that can be tailor-made for my symptoms. I know that my medicine is tested for chemical composition, potency, and whether it contains pesticides or herbicides. I know exactly what I'm getting, such as a prescription obtained from a pharmacy is safer, puts my mind at ease without having to deal with an unknown. I also only need to purchase a 2-week supply, which means I only have in my presence what I'm using at any point in time in my house. Thank you.
Jeff, I have a brief question before we move on. There are some number of dispensaries now, is that right? What happens to them?
Chair Greenlick, members of the committee, we do not specify what happens to those existing facilities in the bill, and we believe that the Oregon Health Authority should deal with that through the rulemaking process and make the decisions about how best to proceed.
So they might move into this dispensary, or there might be other dispensaries move into this field?
That's correct. It would, just as someone basically files an application as a patient or as a registered grower, it would require existing medical marijuana facilities or someone who wants to start one to file an application and go through the process with the health authority.
I know we're very worried in this building about small business, even illegal small businesses. So this would provide some outlet for them to become a registered outlet.
Sure, Green Lake members of the committee, that's a great question. And the truth is, many of the medical marijuana facilities that are operating today have business licenses. They are paying taxes. They are paying employees to work in their stores. And this would actually bring them into a licensed and regulated situation that would probably be much safer and much better for them and for their patients.
Okay, yeah.
Thank you, Mr. Chair. You say there's some testing going on in Wilsonville. Are some of the facilities that are offering marijuana now testing?
Chair Greenlick, Vice Chair Kenny Geyer, yes, that's absolutely correct, but it's somewhat sporadic. Not all of them do it. In fact, probably most of them don't do it, or they do their own testing. This would actually require the health authority to develop rules on exactly how that testing should take place and exactly what they should be testing for.
So when you go buy your medical marijuana, you should check out what they do.
We'll do that. Do you know the cost of it to test and how much that might be passed on to buyers?
Chair Greenlick, Vice Chair Kenny Geyer, my understanding is that is not hugely expensive. There will be other testimony today where I think one of the owners of a medical or volunteer at a medical marijuana facility would be able to tell you exactly the cost that they pay. I think it's somewhere around a couple of $100.
Or how much?
Well, you would test a slump. So what would happen is that a quantity would come into the medical marijuana facility, and they would take a small piece of that and test that. So it would be a small piece of that batch that got tested, and every batch that came in would likewise have to be tested.
And how much is typically in a batch?
Could be anywhere, I am told, Chair Greenlick, Vice Chair Kenny Geyer, from a half a pound to a pound that a medical marijuana facility would get from a grower at any one time, and then break that up and sell it in small quantities to patients who came into their facility.
Okay, so $200 for half a pound or
Somewhere in there.
Thank you. Okay.
Ms. Smurman. Okay, guys, thank you very much.
Thank you, Chair.
Before I call the next panel, I'd like Representative Buckley and Representative Hicks to talk about some of age before beauty.
Absolutely. Thank you, Mr. Chair, members of the committee, Representative Peter Buckley, representing South Jackson County Legislature. First of all, I just want to thank you for taking your time today to listen to these measures. I'm here to testify on behalf of the Senate, or House Bill 3460 and House Bill 2919. And I also note that our excellent member chief of police, Tim George, is here. with their bill as well, and he's an excellent public servant in the Medford area, and I appreciate the time and attention we give to his views on this as well. Mr. Chair and members, the only thing I will say, say a couple things. First, I'm very glad that we got a chance to listen to that panel, the first panel, before we got to come up and testify. They put into words almost everything I've experienced in dealing with the medical marijuana program in Southern Oregon. The consistent communications I get from constituents who are involved with the program are safe access. How do I access medical marijuana in a safe way? And the second is the black market. And unless you live in Southern Oregon, it's hard to understand exactly how the black market impacts you. But it's awful for us. It is everywhere. It is in the nicest neighborhoods in Ashland and the harshest neighborhoods elsewhere in Jackson County. It's in the forest. It's pervasive throughout our region. And the medical marijuana program was never designed to be something that would enhance the black market. This was not the intent of the medical marijuana program. Yet we have a situation where without regulations on growing and distribution of medical marijuana, we have grown a black market in Southern Oregon that is having a tremendously negative impact on my district, on the county, and on the region. So I'm here basically just to make 2 points. Please take these bills seriously. The 3460, which develops the system for growing and distribution, safe access for patients in a regulated manner to cut down on black market activity, is a crucial bill. 2919 is an effort to actually set up a program, do research into what exactly different strains of medical marijuana might mean for a patient. If we're going to have a medical marijuana program, let's make sure it's regulated, let's make sure it's safe, and let's make sure it works the most effectively as it possibly can. We've been wrestling with these issues for years, colleagues, and these bills before you are ways that we can move towards regulation and a more effective program. And again, I'm just here to tell you how important this is to my district, to my county, to our region, to get the medical marijuana program to a place where patients have safe access. I'm sure you can appreciate this. It's a little bit difficult when a constituent calls you up and says, "Representative, where can I get marijuana?" It's a little bit hard to do good constituent services with that sort of question. But we do need a system that is regulated and can work. I'm very pleased to be joined by Representative Hicks today, who's been very open in his consideration of every idea that's come forward, because I believe, I won't speak for him, I believe he shares my view of the necessity for safe access in a well-regulated system. Thank you, Mr. Chair. Thank you, members.
Thank you, Mr. Chair, members. Representative Wally Hicks, House District 3, most of Josephine County. I'm here today on House Bill 2919. I'm not taking a position one way or the other on any of the other proposed bills, but 2919, however, has got my interest in a big way. This is a piece of legislation that, if properly amended, could be really, really excellent. The type of legislation that Oregon can be proud of, even on the national stage, in terms of its approach to medical marijuana and even the entire marijuana question. All questions regarding marijuana should first pass a threshold consideration of federal interest. The seminal case is Gonzalez versus Reich, decided in 2005, which considered medical marijuana and the federal government's enforcement of its own laws in the light of state medical marijuana laws. And the holding of the case basically said the federal government may enforce laws regarding marijuana, medical marijuana, but there are a couple of limits on it. Essentially, from what I gather from talking to legislative counsel, the federal government's interest in marijuana must track the state's interest. And so if the state takes a high level of interest in marijuana, be it enforcement or be it involvement in a significant way, sort of if the state were to be selling marijuana, whether we sell lottery tickets, for example, then the federal government would be entitled by a federal judge to take a correspondingly high level of interest. If the state were to take a hands-off approach to marijuana, then the federal government would be, we think under the case, expected to take a similarly hands-off approach to its involvement, which is typically going to be enforcement. In 2009, the Department of Justice, Federal Department of Justice, under Attorney General Eric Holder, issued new guidelines allowing for non-enforcement of the federal ban in some situations. And the quote here is, "It will not be a priority to use federal resources to prosecute patients with serious illnesses or their caregivers who are complying with state laws on medical marijuana. But we will not tolerate drug traffickers who hide behind claims of compliance with state laws to mask activities that are clearly illegal." which brings us here today, medical marijuana. It's a huge issue in our state, a huge, huge issue. Southern Oregon is bisected by Interstate 5, and there's a huge potential for traffic. In fact, there's a huge amount of trafficking of drugs that goes through our state on any given day. And with our frankly thin law enforcement coverage, particularly in the southern part of the state, we are vulnerable. We're vulnerable to black market access to what is otherwise a legitimate use under state law and is not being recognized at the federal level for medical marijuana. I like 2919 because, and I very respectfully appreciate the opinions of the proponents of the other bills regarding dispensaries, but I personally do not feel dispensaries are necessary. I feel it's an unnecessary node in the chain. It's another place that law enforcement must dedicate resources to monitoring. It's simply, we've gotten to the point in terms of growing and laboratory testing and verification that the most sensible way to get medicine to patients is to have a direct grower to patient relationship, almost an Amazon.com relationship. As in, a patient will know from their doctor which strain of marijuana that's most appropriate for their particular condition. The patient would then be able to find the grower to produce that strain, so producing the strain or produce the strain for them, and the state would have the easiest mechanism, I think, available of monitoring whether that particular marijuana made it to that particular patient without getting siphoned off into the black market. This gives the enforcement authorities the highest level of oversight over the medical marijuana program that I can come up with. And so that's why I do not personally favor dispensaries, but I do very much favor a direct grower-to-patient relationship in medical marijuana situations. Additionally, what 2919 does that's utterly necessary is it allows for monetary compensation to persons who grow medical marijuana and persons who transport medical marijuana to patients within the state of Oregon. Right now, growers are not permitted to cover the expenses of anything other than basically fertilizer and not much else. Yeah, what happens in effect is they make it by selling pot, a lot of them. This is where the black market gets its marijuana. And so the excess winds up getting diverted into the black market, and the citizens of Oregon suffer as a whole. So I say it's time, allow the growers with a high, and they will be subjected to a high level of oversight weekly, in fact, in the particular amendment that I've got here. Weekly level of oversight in terms of where the marijuana is going, but allow them to receive monetary compensation for providing what the state recognizes as legitimate medicine.
Representative, we don't have that amendment, so I think.
Oh, okay, I'm sorry, the
Why
amendment
don't
came out
we-
on Friday, and so I think we
have-
forwarded it to the
we do,
members.
okay.
No?
Yeah, we do have.
We do have, okay.
We would deal with that amendment in a work session. You could briefly just describe what it does.
I shall. Now, this amendment this amendment, I'm still going to need to refine a bit, so I'm going to probably come back to the -3. But what I want to do with this is to, currently cards are permitted to be pooled, so any given card is permitted 6 mature plants and 18 saplings, defined 1 foot in height and 1 foot in diameter. So if you pool, say 2 cards, you're going to have 12 mature plants on any given grow site that have a 2-card pool. And the problem law enforcement is having is they'll come up on a grow site or a suspected grow site, and some of the marijuana, it could be medical marijuana legitimately, but they don't know if all of it's legitimately medical marijuana. And so they get tied down in the process of trying to verify whose medical marijuana site is legitimate, whose isn't, how much of it is legitimate medical marijuana, how much of it isn't, whether it's getting diverted in the black market, and it's a real mess. It's not a workable level of oversight. Law enforcement just can't do that. And so what I'm proposing is that we have large-scale growing operations located in exclusive farm use zones and no more than 1,000 feet from schools and other similar type places of 50 cards or more. And so the 50-card pooling minimum will provide what I consider to be a realistic opportunity for oversight on the part of law enforcement. Just knowing how the marijuana system works, the medical marijuana cards from down in Southern Oregon, this is going to be a huge tool, I suspect, for law enforcement, having the large, scrutinizable sites. So the amendments would do that. There's another, there's a highly concentrated form of marijuana called Simpson oil in the common vernacular, and our lab people can talk about that if you want to hear more, but I would want to see that also prohibited by 2919. It's very dangerous stuff. There's some sense among people who aren't laboratory technicians that it's really good. there's a lore that it cures cancer. There's no evidence that it actually does, and there's solid evidence that it's actually quite detrimental to a person's health. And so I want to see highly concentrated THC eliminated by this bill. And also, I think it's appropriate to
Can I ask you to
yes,
speed up? We have
Chair.
about
Final point. I want to see a county law enforcement offset as a portion of the bill as well. Yeah, so that would be a revenue piece that we could include.
Well, we currently schedule all three of these bills for possible work session on the week of Wednesday.
Okay.
So we would talk about the amendment specifically. Thank you very much.
Thank you, Mr. Chair. Thank you, members.
Call the second panel now on House Bill 3055. Cindy Robert, Chief Kim George, and Brenda McCarthy.
Mr. Chair, members of the committee, my name is Cindy Robert, and I represent the city of Medford. I've spoken to you, along with my chief, to most of you about this bill. I've written to all of you about this bill. I've spoken to stakeholders about this bill, and I've spoken to the media about this bill.
Yeah, which bill?
3055, sir.
3055.
And in all those conversations, we have made it very clear that we aim to do two things. I found out today the bill does a third thing. The two things we intended for this bill to do was to keep grow sites 1,000 feet or more from a school. This is the same as most of the laws that you have all passed in 475 on drug-free zones and all the different areas where you don't want children to be around certain substances. It doesn't change whether it's medical marijuana or regular illegal marijuana. We want to keep that 1,000 feet away. The second thing that we proposed for this bill to do was to limit the number of growers at each site. Right now, we have no limitation on growers. So you can have a lot, a house on a lot that has multiple growers. And in Medford, with a 6 to 7 month outdoor grow cycle, that's a lot of plants in the backyard and really close to a school. So those are the two things we intended for this bill to do. I, not being a lawyer, thought section 2 handled some of the, making sure the language was all consistent with the change in registration identification card holder. But I have since found out that actually on section 2, page 2, line 40, that there's a change on the number 4 to 3 when we're trying to limit 3 growers to a site. This actually limits the number of people you can grow for. If you go back, and I can show you, and look at all my requests to legislative council, that was never our intent. I should have caught this earlier. I apologize to each of you and each person who came here to testify against the bill and took up their personal time. I'm deeply sorry. Our intent was twofold. How close to a school, how many growers on one side. Unlike Representative Hicks, we don't want commercial establishments. This was supposed to be about medical marijuana use on a personal level. Thank you.
Does that mean you're going to have an amendment to the bill?
Mr. Chair, if you should choose to go forward with these 2 restrictions we did want, I wouldn't have back asked for an amendment to be made, but I'll look to you to let me know. Thank you.
Mr. Chair, Madam Vice Chair, my name is Tim George. I'm the Chief of Police for the City of Medford. First of all, thank you for allowing me to speak today. I need to speak on behalf of the City of Medford and also represent the Oregon Chiefs of Police. I'm going to deal with the current law that is in place, and that is what we're dealing with now, because I do believe that marijuana is a drug. I believe it is a medicine. I think that my colleagues in law enforcement, especially the Oregon Chiefs, would be the first ones to speak to the fact that if someone has a legitimate medical need for that drug, there should be an avenue for them to get it. And I am a proponent of the regulation of the current online program. My problem with it is,
Step back.
I'm sorry,
You step back.
I'm too low now, I'm sorry. Cindy said that move it up, so I moved it up. But
Move it back.
all right. The problem with the current OMP scenario that we are in is there's too much unregulation, and there's too much, as previous testimony just provided, it's very difficult for law enforcement to tell who is who, what is what, and what belongs to who. And in House Bill 3055, 2 specific amendments, again, and you got to ask yourself why, and that is we got to limit the number of growers to the grow site, because right now there's no limit to the number of growers at the grow site. It is right for commercial grow operations, criminal grow operations that flourish in Southern Oregon. As mentioned previously, we have an extended grow season. The sign above the main highway in Grants Pass says it's the climate. It is the climate, because we're a climate to grow it, and we export more excess marijuana than any other 2 counties in this entire state. And when I talk about the black market, where that black market marijuana goes, it doesn't stay in this state. It goes east. And we have plenty of proof of that on the return trip, because that's where civil forfeiture comes into play, is the cash that comes back. So we are the #1 exporter in the Pacific Northwest of high-grade marijuana that leaves this state to places far east. And the farther east you go, the more money you make. Specifically, to limit it to the number of 3 growers per site is reasonable, because you can grow right now, and if you take this amendment that we want to take this piece out, you're talking about you can grow for yourself and 3 other people. So now you're talking about 4. So with 3 growers representing 4 people, now you're at 12. So you start doing the math on this, and you're talking about, even with limiting it to 3 growers per site, is still enough marijuana to substantiate those patients that they have to grow for. Look at the numbers and look at the size of the plants. I think that's one thing that really gets lost in the shuffle here, is the size of the plant and the amount of marijuana that a single marijuana plant produces. And we've tested that, and roughly in our grow season, a 7 to 8 foot plant produces 7.5 pounds of marijuana. 1 plant, 7.5 pounds of marijuana. So again, look at the price of that marijuana on the market at $3,000 a pound. You're talking, that's a $15,000 plant at black market prices. So there's plenty of marijuana in the marketplace, and there's plenty of opportunity for patients that need to grow the marijuana that they need. The second piece that I think is just as important, and the last 2 folks that have testified on alternative bills talk about, even they agree that it should not be within 1,000 feet of a school. That is a constant theme here. Well, it's not a constant theme in the current law, because it is not restricted right now. So we're asking for those 2 things specifically. The restriction on the number of growers per site, and the restriction within 1,000 feet of a school. I think that's reasonable. That's what I'm trying to be here. I know the law enforcement gets a bad tag for always saying no to marijuana and no to every marijuana bill. I'm not saying that. I agree with lawful and regulated control of marijuana under the current system. This regulates the current system to a point where I think it's reasonable and acceptable. Thank you.
Chair Greenlick, members of the committee, Brendan McCarthy representing Portland General Electric today. You're probably wondering, why is PGE in front of your committee? So rarely are, and that's true. And I want to give you a perspective on why PGE might care to support 3055, at least in part, specifically around the limiting the number of growers at a particular site. We come at this issue from a system impact issue and a safety issue. When we design our, first of all, we provide power to 828,000 customers in the northern Willamette Valley. 730 or so thousand of those people are residential customers. We have a very compact service territory, and it's 6 counties in the northern Willamette Valley. We see, mostly a cloudy type of weather most of the year. We design our electrical system with anticipation of certain loads. So if we have a house coming onto the system, we size our transformers appropriately for what we would consider to be anticipated residential use. If that use changes in that residence, typically the tariff that we're under, people are supposed to notify their utility that the use has changed, and we can change our system. We can put in a bigger transformer. We can allow more power into that house. Starting about 2011, I started hearing from our operations folks that they were going out and replacing transformers on a more regular basis. It's up to about once every 2 weeks because of a grow operation in our service territory. We have a high concentration of indoor grow operations, and we have a high concentration of medical marijuana cardholders in our service territory. We have a unique situation for PGE. I've talked with other utilities in the state. They are seeing it as well, but not as much as we are. At the end of 2011, there was a house fire in North Portland. Somebody died in the house. He was a medical marijuana card holder. He had a grow operation in the house. We know, not our workers, but when I was talking this issue with other utilities, Columbia River PUD, they gave me a story about how one of their workers was called out for an outage, came up to a grow operation, And the usage from the grow lamps in the operation had overheated the transformer to a point where the oil in the transformer required to cool that transformer was actually boiling. He heard it, he backed away, and the transformer exploded. If he had been closer, he probably would have been killed. We have a safety issue here. We're not making a statement about medical marijuana or the proper use of marijuana or whether it should or should not be legal in the state, but we have a safety issue relating to our grow operations.
Will this bill help that?
Because we'll be limiting the number of grow cards per site, our operations people think that it will diminish the issue we see quite dramatically without doing anything else.
So it would require an unamended bill in order to be
Chair Green, like members of the committee, I don't believe so.
Well, the question is the number of, you said you didn't want to limit the number of growers per site, but wanted to limit the number of users per.
Mr. Chair, Cindy Robert again for the record. We want to limit the number of growers at a site. What we did not intend to do was to limit the personal growth limits of each of the growers.
So the internal problem has to do with the number of growers at an internal site?
Chair Green, like members of the committee, I don't confuse this issue. We don't, the amendment would be fine as we see it. It would be the number of growers at the site. They could continue to grow for the same number of people.
And your problem is there are several growers at a residential site?
That's correct. Several growers will be in a house, and they will have multiple people that they are growing for. So we collect, we have a house, maybe there are 3 or 4 people, and they are all growers, and they can all grow at that site.
Mr. Chair, if I could just add there, I think that Brendan will tell you that Section 2, the change on how many plants you could grow per person, was not something that registering has had either. We all thought the changes we were advocating for were on page 1 only.
And you're thinking 3 growers in a house is okay, but not 4?
Chair Green, like members of the committee, that is what I have heard from my operations folks, that will help.
Okay.
That will help. Do you want me to continue, or?
Yeah, if you could wrap it up.
Sure. Well, just I want to be clear also that we've been on this safety issue. I was actually last summer, I went out and spoke to the ACCM about the safety issue. It was a good meeting, it was a good reception. We've been pushing the safety message, but overall, I just think it's a unique perspective and want to offer our support.
Thank you very much. Thank you all. Yes.
So the limit on this bill would be 12 plants. At what point do transformers start breaking in? What are you typically seeing? How many plants in a home?
Chair Green, like Representative Geyer, I can't speak to the exact number of plants. It's highly variable depending on, again, these are historic infrastructure, and there are still houses in Southeast Portland that have 60 amp service. There are houses that have 100 amp service. It's really unknown, but we don't. There's not a good way for the utility to interface with growers. We're not allowed to have the list of medical marijuana cardholders. It's really, we play catch up. So we go out and we see people with 12,000 kilowatt hours a month of usage. We see the pipe that goes up from your meter, the paint peeling and flaking from behind that, from the heat from the electrical wires. It's not a hard and fast rule, because of course if they had adequate service.
Okay, that was a simple question.
Mr. Chair,
Sorry.
Vice Chair Kennegar, I just want to clarify for you. The law already stipulates how many people you can grow for and how many plants you can grow for those people. We don't want to change that. So the limit is not 12. If you are in a grow site with 3 registered growers, they each can grow for 6 plants for 4 people. That's 24. 24 times 3 is 72. So that's 72 plants. We're not limiting, changing anything about how many plants you can grow and how many people you can grow for. We're only changing how many people in one household can be registered growers. 3.
Thank you very much. I call it the panel for 2919. Seth Crawford, Lucas Littlefield, and Troy Morris, please. Let's try and hold it down. We're going to try and get out of here without having to come back at 6, but I don't know if we can do that. After this panel, we'll have people limited to 2 minutes.
Good afternoon, Chair Greenlick and the House Health Committee members. My name is Seth Crawford. I'm a fourth-generation Oregonian and have a decade of teaching experience at University of Oregon, Willamette University, and OSU. I published scholarly research on the political economy of marijuana, including the first systematic investigations of Oregon's medical marijuana program and Oregon's marijuana using and producing populations. Excuse me. I'm here today to urge this committee to support House Bill 2919. At this moment, 18 states and the District of Columbia have enacted medical marijuana laws, allowing their citizens to obtain legal protection from state authorities to use the drug for qualifying medical conditions. These states account for more than 32% of the total U.S. population, and my research suggests that within the next decade, over 50% of the U.S. population will have medical use provision allowances. Marijuana reform, as we all know, for both medical and recreational applications, is occurring around us with rapidity, though it's being accomplished through direct democracy measures that are not necessarily engaged with our limited understanding of this plant or its social impacts. Researchers have identified 483 active chemical constituents in marijuana. These chemicals, the most important of which are called cannabinoids, have therapeutic potential for inflammatory disorders and diabetes, alleviating muscle spasms, treatment for certain types of cancers, reducing many symptoms of epilepsy, chronic pain, depression, post-traumatic stress disorder, glaucoma, migraines, erectile dysfunction, Tourette syndrome, severe nausea, and wasting disorders. We know, and many of the people in this room have testified to this account, that marijuana is a useful palliative for certain medical conditions. But at this point, we lack controlled studies of the application of specific cannabinoid combinations for any of the before-mentioned maladies. Doctors, patients, and researchers are truly in the dark about proper treatment protocols for this particular drug. Each variety of marijuana, and there are literally thousands of these, contain unique concentrations of active ingredients, which are influenced by plant genetics, environmental conditions present during the plant's life cycle, and its processing into useful medicines. We're at a nascent stage of understanding this particular plant, and no one has offered coordinated leadership to help us move forward. To highlight this point, imagine for a moment that you're afflicted with any of the above-mentioned conditions, and you're researching how to use marijuana to alleviate some of your symptoms. Which variety, or combination of varieties, are going to work best to control your symptoms? What's the proper dose for medical efficacy for your particular symptoms? Will any harmful drug interactions take place? At this moment, no one, and we have a room full of experts on this, can really honestly answer any of these questions in regard to medical marijuana. We know that it's useful, but we're missing some of the research components. House Bill 2919 provides Oregon with an opportunity to bring together the state's researchers, policy experts, law enforcement personnel, and doctors to craft the first coordinated research strategy on this important topic, and it could make Oregon the world's leader in evidence-based marijuana policy research. While many people believe that marijuana's economic benefit will be limited to its sale as a crude agricultural commodity, our visionaries understand that the plant's real value will be derived from unlocking its genetic and chemical potential. I respectfully ask all of you to give House Bill 2919 your full consideration and support its adoption. Thank you for your time today.
Chairman Greenlick and House Healthcare Committee members, thank you for reviewing 2919 today. My name is Troy Morris, and I represent a research project that has been going for about 4 years here in Oregon. Marijuana in Oregon is an issue that people hope is going to be resolved, but for the last 15 years, what we do know is that it's unpractical that it will do that. Our investigations have gone through and gone along and educated from town to town, interfacing with thousands of Oregon medical marijuana patients and participants. We've also had substantial conversations with decision makers to include local, state, and federal law enforcement, district attorneys and assistant district attorneys, general and specialty physicians, medical and analytical chemists, non-medical agriculturists, Oregon's legislative leadership, Oregon's Department of Agriculture, Oregon's Health Authority, Oregon and out-of-state universities, went to Thailand and talked to their university health and their defense ministries, technology and analytical corporations, germane subject matter experts, but especially the issue negative marijuana people. HB 2919 was born directly from the problems that Oregon legislators face, while we explore Oregon's tough questions and persistent problems with science. When we treat marijuana as a technology, Oregon benefits magnitudes more, opening the door to high-tech jobs, capturing research investments, licensing intellectual property, reducing crime, and leading the nation on an important issue. What this means is that Oregon jumps to the forefront of research and technology. HB 2919 directs our state towards an intelligent path with flexibility, transparency, and the resources to tackle the problems correctly, while coordinating with local, state, and federal stakeholders. HB 2919 establishes a fit-to-purpose professional oversight and assessment board of distinguished experts responsible for professionalizing the medical marijuana in Oregon. They represent the experts that we need right now to establish an evidence-based program today. HB 2919 is an innovative plan because it allows a transparent field-to-patient platform driven by clinically relevant data. It includes industrious best practices, and it provides for proactive solutions for enforcement objectives. We just heard them. They made the case for 2919. As an Oregonian, I could not walk past this marijuana problem 4 years ago. Today, after countless meetings, examples, tools, workshops, brainstorms, revisions, I ask you, Chairman Freeland, and the members of this House Health Care Committee, to please grant this fit-to-purpose solution, a work session, and ultimately pass on to the Ways and Means Committee. Thank you very much.
Thank you.
Chair Greenlick, members of the House Health Care Committee, my name is Lucas Littlefield, and I'm here speaking from the front lines of the medical marijuana program. The goal of the medical marijuana program is to serve patients at an optimal level. This means recognizing the solutions when we find them. We, and I mean we, all of us involved here today, need to take the mystery out of marijuana. When we outline patient needs, goals, and requirements, we engage their physicians, because if marijuana is medicine, then it should be treated like medicine. The effects should be measured, the outcome assessed, and nobody should wonder if marijuana is working. We would know. These are the important points to a marijuana program that works. Proactive solutions meeting enforcement objectives, specifically law enforcement objectives. A reliable source for usable best practices. Transparent tracking and inventory systems, making sure that marijuana goes where it should and not anywhere else. A core team demonstrating a professionalized program. Training and education for all involved participants. Evidence-based decision-making and research. Coordinated leadership throughout the program. Good actor accountability, again, throughout the program. A responsible fit-to-purpose framework. And professional oversight board of experts. All of these things are a requirement for a professional medical marijuana program, and this is what I would need to establish a responsible and accountable program from the front lines. House Bill 2919 is a tool in order to create trust. It is a pilot program, asking for and delivering proof, not propaganda, that we will find the best way forward in this industry. This is Oregon's chance to step up, to be a leader in the scientific exploration, and to treat marijuana as the potential technology that it is. The marijuana movement is a national one. It is one that may or may not leave Oregon behind, and it is not asking for Oregon's opinions right now. Yet Oregon could become very easily the leader in this national movement. In realizing this, we asked ourselves, how can legislative leaders force Oregon forward without truly understanding marijuana? Are we truly racing down this hill blindfolded, following other blind leaders in this camaraderie of a possible conundrum? Instead of leaving it at simple rhetoric questions, we co-drafted House Bill 2919 with legislative leaders in Oregon, experts we consider them, because this is the right step forward. Understanding marijuana is the right way to go. Representatives, your support of this innovative approach reveals the potential technology that marijuana is, and potentially converting it into a productive resource for Oregon and for the nation. When applied accurately, it is capable of medicinal grade solutions. 2919 would initiate those medical advancements and create full-time research positions and jobs that accompany those positions. Folks, to be completely blunt, we need this bill if we are to move forward with marijuana as a state and in this country. We need to understand what this is. We need to understand it professionally, and we need to understand it so that we can teach our people what it truly is and understand what it is not. Thank you all very much for taking the time today. We truly appreciate the honor of being here, and please, we hope that you see the support in 2919. Thank you.
Thank you, guys.
Mr. Chair?
Yes.
If I may, because I've worked with these guys quite a bit, there's a couple things I'd like to have them explain, if I could ask them a question.
Well, okay, I'd like to be out of here in a half an hour. We've got about 15 more.
Because this is the bill that actually really intrigued me. And Troy, if you could explain just the nuclear material transfer system, how you became acquainted with it and how you would implement it into 2919, and what your thoughts were on that.
So my background is in
about 30 seconds.
Is in chemical engineering and organic synthetic chemistry. And I became the project manager on an Oracle rollout for a shop floor data management program to track nuclear level materials so that they wouldn't accidentally get in the hands of bad guys. And so ultimately, the problem with a continuous manufacturing oversight when you have a farm is that it is discrete manufacturing, meaning it's steps. And so discrete manufacturing model that can track zirconium, titanium, hafnium is more than qualified for being able to track that.
I'm going to ask you to provide this information in writing for us.
Absolutely.
I really do want to move on. Is there another piece you want to make sure that you
Yeah,
provide?
I mean, that's a lot of it is the tracking of it and actually treating it like it is a medicine for our patients and coming down to it with the genetics. And there's a lot of good stuff that we were working on in 2919. Actually, my staff, I had them spend a lot of time and work with them. Jeff was involved. All three of these bills, there's some great, I could see all three of them kind of working together in this program. So anyway.
Thank you very much. Sure, thank you. Let's take the other two people on 2919 who have requested to testify. That's James Bowman and Jenny Lee. Is that Jenny? And we're going to hold everybody to 2 minutes now, please. I prefer not to come back at 6 if you can avoid it.
Both up here at the same time.
Yeah, both please. You can check for head, please. You have time information.
Chairman Greenwood, Vice Chairs, and all the members of the House Health Care Committee, thank you for the opportunity to address the committee and address HB 219 today. My name is James Bowman. For over a decade, I've cultivated and processed cannabis for myself and for patients who couldn't produce for themselves per the Oregon Medical Marijuana Act. I'm here to support passage of HB 2919 and to encourage your committee to move this important bill forward. HB 2919 represents a thoughtful and seriously needed upgrade to the OMMP. HB 2919 will give the OMMP, the Oregon Medical Marijuana Program, the fact-based authority and intellectual oversight it has been lacking for 15 years. The many challenges inherent in today's OMMP can only be solved with a governing board that all the stakeholders associated with the OMMP can both rely on and defer to. HB 2919 is that solution. There is no doubt in my mind that if HB 2919 is added to the OMMA, the Oregon Medical Marijuana Act, it will be stronger legislation, and Oregon will again be the leader and an example for the rest of the nation. Thank you for your time and consideration.
Thank you very much.
Hi, and I just want to ditto to everybody else.
Introduce yourself, please.
Jenny Lee. And I agree with everything everybody said.
Thank you very much for your brevity. Now we'll move to a panel on 3055. We have two opposed and one I'm not sure. Let me call Cheryl Smith, Todd Milano, and Anthony Taylor, please. Go for it.
My name is Cheryl Smith. I'm Executive Director for Compassion Center in Eugene, Chair and committee members. I'm opposed to Senate Bill or House Bill 3055. I think this is a solution without a problem to solve Right now, we have patients who have problems finding growers. This will only exacerbate the problem if you cut down on the number of growers. Probably the biggest problem is there is a faulty assumption I heard in the proponents of this, that each grower grows the maximum amount they're allowed to, which isn't the case. Some people, let's say there are 4 people living in a house together, they're each growing for themselves. They now can't grow for another patient. Not everybody who is a grower grows for 4 patients. So it doesn't make sense to me to cut down on the number of growers from 4 to 3. Thank you.
Thank you, Chair and Committee. My name is Todd Delato. I am a horticultural researcher specializing in cannabis. I also chair the State's Advisory Committee on Medical Marijuana. I had worked with Brendan McCarthy from Portland General Electric, who was testifying earlier. And we were working on drafting a cautionary statement for the Oregon Medical Marijuana Program to distribute to their cardholders regarding basically encouraging them to report their use of electricity to PG&E so that they can effectually install the proper transformer in the person's neighborhood to avoid the overloading and boiling and safety problems that he described. And I agree wholeheartedly with Brendan McCarthy's concern over the safety for both residents as well as PGE service workers. However, I don't feel limiting the number of growers per address or plants per address would address that. I think making this making it easier for people to report to tell PG&E that they're growing marijuana, or at least using a high level of electricity, would be much better than just limiting it. And I think by passing a safe access bill would help people feel comfortable about reporting their electrical usage regarding their medical marijuana grows to PG&E. Also around schools, we already have many provisions to protect children, and I'll stop it right now, but I'll submit written testimony later.
All I had to do was point, that's good.
Sure.
Thanks, Mr. Chairman and members of the committee. My name's Anthony Taylor. I'm with Compassionate Oregon, and I would also let the record show that I am a constituent of Representative Widener. I would like to also echo Mr. Delato's concerns about the 1,000-foot rule, and to say that this basically precludes anybody in a residential area, in a sense, from providing themselves with their own medication. And the last thing I'd like to point out as a matter of mechanics, on page 3, section 4, the emergency clause, if you're seriously considering this bill, I would encourage you to drop that particular section, because it would, the mechanics of getting everybody in compliance with this, if adopted, would be huge, and you should allow them the time to do that, and perhaps maybe make it become effective at the first of the year 2014. Thank you.
Thank you very much. We're now on the 3460, is that right? Yeah. And we'll go down the list and take as many as we can. Ken Nichols? Is Ken Nichols here? I think not, okay. Wes Robertson?
Yes.
Jim Grieg, please join us. Don Morse? I think we're going to make it. Please somebody start.
Okay. My name is Wes Robertson, and I live in Medford, Oregon. I'm 51 years old, and I was born with cystic fibrosis, a recessive degenerate disorder with, my head injury, which mostly affects my lungs. In 1980, I was in a car wreck, which resulted in a brainstem injury. That injury has caused me to suffer with a seizure disorder. I'm permanently confined in a wheelchair. I am a medical marijuana patient. I use cannabis to combat pain of my injuries, to control my seizures, and expectorant to expel this excessive phlegm, caused by my cystic fibrosis. Without my medicine, I would not enjoy the quality of life that I do have today. My disabilities make it possible for me to grow my own, my disabilities make it impossible for me to grow my own medicine. I do not have the mobility it takes to tend the plants, nor the strength or stamina to harvest them. It is it is very difficult for patients to find someone who is willing to become a grower. And for people like me, it is even more difficult. If I cannot grow my own medicine or find someone to grow it for me, my only other option is a dispensary or some way to call them safe accents, or to call some way, dispensary, or some may call them safe access points or resource centers, whatever the label. I, along with thousands of other patients, simply know them. My trusted safe access point, has become my only trusted source of community connection. It has taken me from dangerous black market hookups and prices to a clean and professional environment. I think it is fundamental for patients with disabilities to have a safe place to get their medicine, a place where cannabis is tested and proven safe and effective, and where there are acknowledgeable people capable of helping us to choose a strain that will work for our conditions. With the hundreds of disabled patients in Oregon who are forced to either go without their medicine or buy on the black market, the fact is there is nowhere for them to legally purchase medical marijuana. Or cannabis, with only perpetuates the criminal aspects of marijuana. I am one of the lucky ones. I found a place, I visit a community center in Southern Oregon that has respectively been assessing patients and educating the, I'm done.
Thank you very much.
I'm sorry, I didn't do it.
We really appreciate it.
Head injury.
We usually have to just deal with a bunch of obvious human stories every day.
Thank you.
Please.
My name is Jim Gregg. I'm a member of the board of directors for Voter Power. I'm an organizer for Americans for Safe Access. I was the co-director for Measure 74. I'm here to, first off, thank you for having hearings on medical marijuana. With the country all abuzz on legalization right now, it's good to hear that we're still making forward progress here for patients. Patients like myself who can't grow their own medicine, I can't emphasize enough how much 3460 will help us find consistency in supply, both in availability and in quality control. Over the years, I've seen a number of volunteer growers come and go, quality ranging from excellent to poor or even non-existent. 3460 is a balance of meeting patients' needs with responsible regulation. Key component requires the tracking of all medicine, what goes in and what goes out, to make sure there's no leakage that the law enforcement officers have talked about being a problem. I think this bill would provide at least better grower-patient relations. Growers are looking forward to the chance to receive compensation for their time and energy, and it stands to reason only patients who receive an adequate medicine from their grower are going to sign the release to allow that medicine to be released. Legalization might be right around the corner, but we patients need a better program now. 3460 is a big step toward that goal. Came here today to ask for you to pass recommendations on 3460 as well as your help in moving the bill forward as quickly as possible. Thank you.
Thank you.
Chairman Greenlee, members of the House Healthcare Committee, my name is Donald Morris, and I'm here representing members of the Human Collective. I am one of the volunteers who operate the Human Collective in Portland. Human Collective was founded 3 years ago this month as one of the first facilities in the area to offer OMMP members safe access to medicine. Since its inception, it has sought to provide medicine in a safe and responsible manner consistent with the OMMP. Human Collective exists to meet the growing demand of patients who cannot find growers and who cannot or do not wish to grow for themselves. I was prepared to present this committee with over 50 patients who could each testify as to the unique circumstances that make obtaining medicine at a medical marijuana facility necessary or desirable for them.
Thank you very much for not doing that.
You're welcome. In the interest of expediency, I was asked to make their case for them. For over 15 years, Oregon has allowed medical marijuana for those who qualify. However, it is yet to establish a safe and regulated system for patients to access the medicine. Once a patient is registered with the OHA, OMMP, they are left to their own means, unlike a patient who needs oxycodone or Vicodin, who would only have to go to their local pharmacy. I believe that in the beginning, it was thought that those wishing to use medical marijuana would have no problem growing it or finding someone to grow it for them. That is not the case today. The reasons are many. Patients have jobs and families, don't have the time. Some live in apartments, retirement homes, hospices, assisted living facilities, Section 8 housing, or some other circumstance that prohibits their own garden, even if they wanted to grow it. Some don't have a green thumb, while others lack the mobility or strength to do so. And for some, they simply have no more desire to grow their own medicine than they would to raise a chicken for tonight's dinner. Those who do not grow for themselves try to find someone to grow for them, but finding a grower is not an easy thing to do. Most patients do not know a grower or have someone willing to grow for them. The law as written requires patients to forge relationships with people they do not know in an effort to have access to medicine. For many, this is a scary and troublesome process, but even more so for elderly patients. We have an ever-increasing elderly population choosing medical marijuana in place of more traditional medicines. These patients represent the majority of those who have no idea how to grow it for themselves and no way to find a grower to access it. Their options are to shop in the black market or to access one of the safe access points that exist today to meet their needs. There can be little doubt as to the legality, risk, and potential harm patients face when accessing medical medicine on the black market. And the more socially responsible medical marijuana facilities that exist do so in a gray area of the OMMP that puts patients and providers at the mercy of the interpretation of the law by local law enforcement. Oregonians registered as patients who take the appropriate steps to acquire the registration deserve safe access, and HB3460 does just that. The voice of the patients I am representing here today, one being my wife, implore you to vote yes on HB3460. My wife is not a criminal for using medical marijuana. I'm not a criminal for providing safe access to it or to others. And this bill assures us that patients and their providers can work together to provide safe access. Thank you.
Thank you very much. 3 more, we're going to make it. Todd Delano, Jerry Wade, I think, and Cheryl Smith.
Thank you, Mr. Chair, members of the committee. As mentioned before, excuse me. Yes, thank you. Todd Delano again, horticultural researcher specializing in cannabis, chair of the advisory committee on medical marijuana. In addition to those 2 roles, I also do a lot of expert witness and expert consulting work for criminal defense attorneys. And so I've reviewed discovery evidence against dozens and dozens of cases involving distribution of cannabis for medical purposes and otherwise. So I've seen a lot of cases, read the evidence of dozens of well-intentioned people who provide seriously ill patients with medical marijuana in a manner that's largely compliant with ORS 475.304 sub 7. That's the reimbursement section of the Oregon Medical Marijuana Program. Yet they are been prosecuted by law enforcement largely because law enforcement sees exchange of money concordant with the exchange of marijuana to be a felony, regardless of their compliance with the reimbursement policy. So unfortunately, I've seen a lot of people being prosecuted who are very well-intentioned and compassionate. I've also seen a lot of evidence involving cases with not so well-intentioned patients, or excuse me, not so well-intentioned growers who divert medical marijuana to the black market. And I think that is largely a concern of probably everybody on your committee. But if you're interested in clearing up the gray area that the dispensaries are currently operating under, as well as in encouraging compassionate, good, well-intentioned people to be able to exchange medicine for reimbursements, and also to provide a disincentive to the not so well-intentioned people, I think passing HB3460 is the best option to do it concurrently. Thank you.
Hello, my name is Jerry Wade, and I'm here representing the Stormy Ray Cardholders Foundation. For the last 14 years, SRCF has actively supported and defended the right of medical marijuana users. Many of you know Stormy Ray was the chief petitioner for Measure 67 that began the Oregon Medical Marijuana Program. And our primary concentration, and in 2005, we helped pass Senate Bill 1085 that increased our limits and helped curb abuse within our program. There have been many attempts to create a medical marijuana supply system here in Oregon, but until now, SRCF have been able to support any of them. Past proposals failed to protect the patient's interests. These attempts have primarily concentrated on generating tax income and profit and have not focused on providing affordable medicine to the patients that use medical marijuana. Many medical marijuana patients live in HUD housing, which bans the growing of medical marijuana. Other patients simply do not have the space needed for the garden or are physically unable to grow their own. SRCF estimates almost half of the registered patients under our program do not have a consistent, affordable supply of medicine. If excessive fees are allowed to drive up the price of our medication, OMM patients will continue to purchase their medicine through the black market or more likely go without, thus defeating the purpose of this legislation. To suggest there is a shortage of marijuana in Oregon is laughable. The problem is that most patients cannot afford the current prices they have to face on the black market or afford to grow for themselves. Often the most disabled patients have the least access to the medication they need. Most patients use 2 to 3 ounces of medical marijuana per month, and many times it can be sold for over $200 an ounce, and yet it's produced at under $50 an ounce on average. One of the things I would like to also comment on is under the on 3055 is the suggestion that outdoor grows within 1,000 feet of a school be banned, and that would be very problematic. Most patients in our program are over 50 years old. The ones that are lucky enough to be able to produce themselves often is because they own their own house and are able to grow. You can't just sell your house and move if you happen to live within 50 feet of a 1,000 feet of a school, so it would ban most patients that are currently able to have a garden from producing their own medicine, which is the cheapest, most affordable way that patients can access their medicine. I do agree that in residential neighborhoods that marijuana should not be allowed to be produced outdoors in residential neighborhoods within 1,000 feet of the school. I can see how that could create a problem for people seeing it. But, okay, but I see no reason for indoor gardens to be blocked from 1,000 feet of the school. Thank you very much.
Chair Greenlee and committee members, my name is Cheryl Smith. I'm Executive Director of Compassion Center. I also serve on the Advisory Committee on Medical Marijuana. and I'm testifying in favor of HB 3460. Compassion Center is a nonprofit medical marijuana clinic and educational organization in Eugene that serves about 1,500 patients a year. That's either people who have or are applying for a medical marijuana card. Much of what Don Morris told us about the reasons that people can't get medical marijuana, I concur with. That's what we found too. After paying $250, we often have patients call and say, okay, I've seen my doctor, I've got my card, now where do I get my medicines? And they have no idea. And in Eugene, we have very few of these marijuana outlets. We also have a lot of older and really infirm people that come through our clinic, and they don't know anything about the black market. They've never been involved with it. This is their first chance. They're just desperate to get off of the opiates, and so they're going to try medical marijuana, but they have no way to get to it. So our current system isn't working, and HB 3460 would create a system that will work for all patients. It would also encourage the development and improvement of other ways for patients to use their medical marijuana that don't involve smoking. And this is something that our physicians are really big on. They don't want patients smoking. The average person can't create these different methods of using the marijuana, whereas these safe access points would be able to do that. So I encourage you to pass HB 3460.
Thank you very much. Before I close the hearing on these three bills, we have them tentatively scheduled for work sessions a week from Wednesday. That's the last possible day we can work a bill. So if any of you have any amendments, in case, I'm not guaranteeing we're going to work all three bills, but in case we do, if you have an amendment on them, you need to get it to Mr. Lawson by Friday, this Friday, because otherwise we need to get it processed and get a fiscal on it. If we're going to work it, and it'll be too late to do anything. And if we wanted to pass the bill, we don't want to not pass it because we don't have the paperwork to get it done. So if you think you have a way to improve the bills, and you intend to put any amendments in, or any of us have any amendments, let's get them done if possible by this Friday so we can make sure the work can go forward. I thank you all for being time sensitive to what we're doing. We got through in time, and that's a very pleasant surprise. I'm going to close the public hearing on HB 3460, HB 2919, and HB 3055. And we are adjourned almost right on time.
Thank you. You want to say anything before I turn it off, Glenn?
Yes, good night.
Good night. God bless you all, every single one of you.